My name's Jennifer Canis and I'm a councillor here at the City of Melbourne, and it is my great pleasure to welcome you all here today. Can I begin by acknowledging the traditional owners of the land we're on and pay my respects to their elders, both past and present. This has been a really important week for Aboriginal and Torres Strait Islander people in Melbourne, but it has also been a very important week for the City of Melbourne in our relationship with the Aboriginal and Torres Strait Islander people here. If you haven't already had a look, when you leave, if you go onto the Collins Street side and have a look up, and you'll see flying there the Aboriginal flag. And that flag will be flying there permanently from Town Hall from now on. And from my perspective, that was a really wonderful way to recognise and celebrate the contribution of Aboriginal people in Melbourne. But today, of course, we're talking about the contribution of another significant group of people, and of course a very significant man. But Mabo was a spectacular decision. It's really hard to think now that it was 20 years ago. So I'm really looking forward to hearing what's going to be said today. And so without any further ado, I'd like to ask Margaret to come and give us a welcome to country. Thanks very much.
Thank you, Jennifer. It is my pleasure to be here this afternoon to welcome you to the land of the Wurundjeri people, the traditional owners of the majority of the Melbourne metropolitan area and the surrounds. We're here fairly frequently. Probably first time for me was, I think, NAIDOC way back in 1976, I think it might have been, where at that time the judging of the Miss NAIDOC used to occur because it was the only place that we could get that was large enough, more or less central enough, and didn't cost anything. And I have to say to you, the rooms would be full of mothers and young girls and relatives, and all of us being excited about being able to celebrate a number of days for ourselves, gathering together and enjoying, I think, surviving. We're here today, though, to talk about Mabo 20 years later, 20 years on. I'm sure the speakers will have a number of things to say about that. Before I go any further with my welcome to country, though, I'd ask you all to join with me in a minute's silence for Eddie Kuiki Mabo, who passed away before the judgment came down in relation to his rights on his island. And thanks to him, he started, I think, to raise the status of Indigenous peoples within Australia, Torres Strait Islander people being autonomous and having their own authority, and Aboriginal people on the mainland having theirs. But he was a very brave man. It ended up taking his life, and I think we should honour his memory by giving him a minute's silence. So if you'll join with me, please. Thank you very much. Since the time of Eddie Mabo, every nation in Australia has lost people, not just the old, but the young as well. Native title, I think, was a bit of a beacon of light for everyone, but since then it has taken people's lives. They've tried to, survive long enough to get some result for their families and their nation. Sadly, though, many have also passed on, and our minute's silence could also reflect memories of them. I'm here to do the welcome to country for the Wurundjeri people. I'll deliver that in the Wurrung language, the language of the Wurundjeri. Wamidjika Yemen Kundi Bik Wurundjeri Balak. Welcome to the land of the Wurundjeri people, and I'll hand over now to Adam McLean, who's going to, I won't say referee because he won't need to do that, because we're all sitting here wanting to enlighten yourselves on native title and where it's at now and where we're hoping to go to. So thank you very much.
Well, I thank Margaret for her welcome. and I welcome everybody here to the Melbourne Conversations and brought to you by the City of Melbourne. My name's Adam McLean. I'm a barrister that's been doing native title and land rights for over 20 years, mostly in New South Wales and Queensland, and for the last 5 to a bit longer years I've been doing that down in Victoria, which is where I'm originally from. I'm going to introduce our panel. The person who just gave us our welcome, Margaret Gardiner. Margaret Gardiner, she's Wurundjeri, Waveroo, Tanarong, Nirom, Ilom, Wurrung, Wamba Wamba, Barappa Rappa, Jar Jar Wurrung. She was, for a time, the acting CEO of the Native Title Services body prior to the one currently acting, which is Mirumbiak. She's the Traditional Owner Land Justice Group member and a Mildren member. She tells me she can walk from her house in Dandenong all the way to the Murray River and always be on her country. We have Gary Murray, who's a Wamba Wamba, Barappa Rappa, Jarjarong, Yong Belong Clan, Yapagok, Wagaya, Wadjabolik, Yorta Yorta, Judarawa, Wurundjeri person. He's also on the Land Justice Group and on the Mildren Committee. And so together, with these two people here, we have some of, basically most of Victoria covered as far as traditional owners are concerned. And these people have been involved in native title since the year dot. We also have Matthew Storey, who's the CEO of Native Title Services in Victoria. Native Title Services, or NTSV, is a body that assists traditional owners to do their native title claims throughout Victoria. Matthew took up his position as the CEO earlier this year. Prior to that, he was in the Northern Territory for 25 years, and he worked in the area of land rights and native title as a senior Crown Law Officer with a solicitor for the Northern Territory. He's also was the head of law at the Charles Darwin University, president of the Law Society and the director of the Law Council. So Matthew is also able to bring to this conversation his knowledge and expertise and experiences from the Northern Territory and his experiences to what's happening in Victoria, because I really want this conversation to talk about Mabo in general, and as the format of today I'm going to give a bit of a background to native title and the Mabo decision, but I'd really like to hone that down, speakers, if you get the opportunity, to bring it down into what's the situation in Victoria. I'll have a little introduction, the speakers will have something to say, and then we'll throw it open for questions. So we'll have about 15 to 20 minutes for questions and a discussion. So it was 20 years ago today at 2 p.m. on the 3rd of June that the Mabo decision was handed down. So we're really exactly 20 years ago today. And that decision was made 10 years after Eddie Mabo and the other applicants, David Passy and James Rice, brought their application against the Commonwealth and the state of Queensland for native title rights. And unfortunately, as we know, it was 5 months after Eddie Mabo died before the decision was actually handed down. 6 out of the 7 members of the High Court recognised that Australia has a form of, the common law has a form of, should recognise a form of native title. And critically, the High Court found that the rights and interest in land possessed by Aboriginal people survived the changes in sovereignty as a burden on the radical title of the Crown. But it was a significant decision, and mostly significant is because it had changed everything that had gone in the past. And that was a huge leap forward for the High Court. And I'll read just one paragraph from Justice Brennan, if I may, where he says, "It must be acknowledged that to state the common law of Australia in this way involves overriding cases which have held to the contrary. To maintain the authority of those cases would destroy the equality of all Australian citizens before the law. The common law of this country would perpetuate an injustice if it were to continue to embrace the enlarged notion of terra nullius, and to persist in characterising the Indigenous inhabitants of Australian colonies as people too low in the scale of social organisation to be acknowledged as possessing rights and interest in land." And I think that's the key paragraph of the judgment. The legal concept of terra nullius, as we all know and we've been told a million times, was overthrown by that definition. But that legal definition of terra nullius was never that there was no people here. It's just that under the English colonisers, and if they're using their legal rationale, was that the people here, yes, there were people here, but they were too low in the social organisation to be acknowledged by English law as possessing rights and interests. Now, that whole basis, of course, was thrown out by the Mabo decision. And it's, I've been reading it over the last week, and it's a difficult, complex decision, especially if you didn't have a good understanding of English property law before, and how English property law was received into Australia with the planting of the flag by Captain Phillip in Sydney Cove in 1788, and what laws came to Australia. So just reading the decision alone, it seems an interesting decision, but when you see what it did, what it changed, and how it overrode all the decisions in the past, you see what a kind of radical decision it was. The other thing that is important to know about Mabo is that, and I know we're all aware of this, but it's good to remind ourselves that Mabo confirmed that the sovereign can extinguish native title, and by grants that are inconsistent with native title. And so grants of freehold extinguish native title. And so, freehold land, the backyards, as it were out of the picture. Now that's significant for the east coast of Australia and highly significant for Victoria, because so much of the land where native title has been extinguished. What we're talking about is what's left over, the crumbs that the state hasn't given away as freehold or other grants. Also during my research, I thought I'd have a look at the debate that was going on around there, because I remember the debate in the media was fairly controversial. And if I talk about the debate around carbon tax and the mining tax being toxic, when you look back then, it really was something to behold. So if I can take you back to 1992 when this decision was made, 20 years ago today, if you recall, the Prime Minister was Paul Keating, the Governor-General was Bill Hayden, Premier of Victoria was Joan Kerner, and then Jeff Kennett took over in October. We're starting to get a bit of familiarisation, yeah. Hawthorn were the reigning premiers, and Achy Breaky Heart was the #1 song for the year by a long shot. So things were pretty crook, I would have thought. After the decision, Prime Minister Paul Keating said it represented the removal of the greatest barrier to the process of reconciliation with Aborigines. So, that was a big decision, but also big statements by the Prime Minister. Robert Tickner, the then Federal Minister for Aboriginal Affairs, said it will be the most analysed and dissected decision in the history of the High Court. Well, that's something I think probably has come true. Pat Dodson, the then Chair of the Council for Aboriginal Reconciliation, said the decision was received in a spirit of joy and celebration. Father Frank Brennan, he's the son of the High Court judge that I just quoted, and who Paul Keating called at the time the meddling priest, if people recall that, said the decision set the foundations for more just land dealings in Australia and for a possible reconciliation between black and white. Noel Pearson from the Cape York Land Council said it should form the basis for some form of future self-government within the nation. So there were high hopes at the time of the decision. Others were more cautious. The lawyer Michael Mansell said the court gave an inch but took a mile, and offered too little and nothing in the way of justice. That was his prediction. Charles Perkins, I think, saw the decision for what it was and how limited it probably could be, especially for those people on the east coast of Australia, and said that decision should lead the way for a discussion about sovereignty, national land rights, and a treaty. And you might remember the discussion then. On the other side of the coin, we had people like Hugh Morgan, the manager of Western Mining, who was just in the paper the other day, said that such calls for reconciliation was an exercise in the politics of guilt and that terra nullius should remain. And he said that the High Court seemed shamed of being Australians, and it carried the seas of territorial dismemberment of the country. Colin Howard, a Melbourne QC, who was also in the paper just recently on Friday, as he's passed on now, but has his connections with the politician Sophie Mirabella, he said that it enabled a nation within a nation, complete with homelands. Patrick McGuinness and others called for a referendum to overrule the decision in Mabo. And there was a lot of worry, especially by Paul Keating and others, that such a referendum would really have a period of really racist and toxic debate, that if it really was a race debate around a referendum. The West Australian president of the Pastoralists and Graziers Associations said that Mabo was the worst disaster since World War II. So if we can remember how heated up that debate was then. Paul Keating then countered with his Redfern speech towards the end of 1992 and again called for a discussion and a conversation about reconciliation. It didn't work. Shortly thereafter, historian Geoffrey Blaney said that the Chief Justice should resign and make a way for a Chief Justice who was prepared to carry out his duties. And that led at the time for Archbishop Desmond Tutu to wade in And he said that if we didn't work out a way forward and dealt with reconciliation properly, we would live with a legacy that we would not be happy with. Then came, I'll just grab it, this lovely piece of legislation, the Native Title Act, which we're all dealing with day in and day out. And that was the government's attempt to deal with the Mabo decision in a way that wouldn't leave it totally up to the courts making all those decisions every time. And if you remember, it was also the longest debate in parliamentary history when the Senate finally passed the legislation and became in force on the 1st of January 1994. Again, Paul Keating said it was a great turning point in the history of Aboriginal people of Australia. Noel Pearson also supported it as an important first step in the process of reconciliation. Of course, Dr Hewson, the leader of the opposition, said it was a day of shame for Parliament and an absolute disaster for Australia. And he said that it would lead to divisions within the country. Well, we'll get our comments from our commentators to see if that's actually happened. Noel Pearson, although, he remarked that the Mabo legislation was the minimum that could be given with any decency and left Aborigines with less. Robbie Thorpe, Victorian, that is known to us well, said that the legislation justified white occupation and took rights away from Aboriginal people. Just a few other comments from other people. I mean, Richard Court said that the proposed legislation would lead to a form of apartheid, and the head of the National Party said it'll lead to West Australia attempting to secede from Australia. We always hear that one. The debate got quite toxic. The head of Lehman Brothers said that if the decision and the legislation would mean that Australia would go back to being a Stone Age culture of 200 people living on witchetty grubs. I mean, these are people making these incredible comments in the public. Premiers Court and Kennett, of course, said that the backyards are under threat, and it was clear, so clear that that was not the case, but, you know, stir the pot. And I've got a whole lot of comments from people where the debate really sunk to very low points. One of the lowest points, I think, was Patrick McGuinness, who said that the legislation was erecting yet another tier of administrative and quasi-judicial bureaucracy which will create another form of army of white parasites upon the Aborigines. Well, I hope he wasn't talking about lawyers in that case. I assume he was. Terrible thing to say. But Neville Bonner weighed in, and he said that both sides are acting like silly buggers. So I thought that was pretty accurate. More recently, and just in the past couple of months, we've had former Prime Minister Paul Keating supporting the Chief Justice of the High Court, saying that the native title legislation maybe should be reviewed to reverse the onus of proof, to say that, look, native title, let's just assume native title exists in this country, unless it's proved otherwise by the states. Now, they would still be able to prove otherwise for most of the land. So therefore, we'd still be talking about what's left over, but we wouldn't have to jump through these ridiculous hoops in order to establish native title. And, you know, we've got the Chief Justice of the High Court calling for it. I think that should really be given some credence. And I hope today, from today onwards, the discussion around Mabo might talk about the legislation and how we can best change the legislation to make these things happen. Now, I'm going to just move the conversation to Victoria, and then I'll hand over to our panellists. Professor Mick Dodson said last year that native title has not worked for Victorians' traditional owners, and he pointed out that 0.05% of Victoria is Aboriginal owned. That's the lowest by any state in Australia by a long way, even greater than, we're even worse off than Tasmania. We've had 74 claimant applications. In reality, there's 4 claimant applications that are running in Victoria. The 2 speakers we're about to hear from are involved in most of those. There's, for example, 40 Indigenous land use agreements in Victoria compared to 400 in Queensland. So Victoria is really lagging behind, and the prediction is that if Victoria continues to lag behind, it'll take another 30 to 50 years to solve the native title claims in Victoria. The claims that are on foot that both Gary and Margaret are involved with are all over 12 years old. So we're dragging the chain here in Victoria. In some recognition of that, the former Labor government of Victoria passed the Victorian Traditional Owner Settlement Act in a way to try to move some of these settlements through. We refer to it as the TOSSA Act, but I think it has got some key elements that we're all now operating under as we try to progress native title in Victoria. Professor Mick Dodson said it was a significant and lasting reform that should bring native title in Victoria into the modern age. Gary Murray at the time questioned whether it could really achieve what it set out to achieve, and there was a bit of a debate around it, but it's still new and we're going to see where that goes. So look, I will now hand over to the panel. I might ask Margaret whether, and using your Victorian experience, whether you thought Mabo is a decision that should be welcomed by all Australia and the removal of the greatest barrier to the process of reconciliation, as per Paul Keating, or did it offer too little and too late in the way of justice for Victorians by Michael Mansell? What are your thoughts on that?
Well, it's been difficult for the Wurundjeri people, for instance, to think about putting in a native title claim. A claim was prepared, it was about that thick. It didn't have all the titles for land that was available attached to it, but it was put together, never signed, never lodged. The reason for that mainly was that for Wurundjeri it'd be like holding a sieve up to your face and getting a texture and putting a dot through a hole as to the small pieces of land that we would be able to include in the claim, because Melbourne is so settled and it's growing. So at the time it was, Wurundjeri just didn't get involved. But I have to say, on the other hand, that the Wurundjeri people have an organisation now that's a couple of $1 million in value, and every dollar we get, we make ourselves. So native title hasn't done anything for the Wurundjeri people. We've had land grants from the Commonwealth and the state that make up our land holdings, but that again was land grants done by acts of law at state or Commonwealth level, not the Native Title Act. Have been involved with other groups that I'm connected to in relation to not just native title but the Traditional Owner Settlement Act, and there's a lot of thinking, a lot of talking, a lot of emotional stress that comes with that, because as you continually work out how to get around a problem that either the state puts up or another group might put up, or a problem that is created internally, the goalposts seem to change, and we've got to come up with another strategy of how to ensure that we're able to manage to use the systems that are available to us and the tools that are available to us to try and reach some purposeful end. And right now it doesn't seem like the end is very near, but people keep trying. And I'll just make a statement right here and now. I think Aboriginal people in Australia are probably the most adaptable people on the planet. We've had untold of numbers of pieces of legislation enacted for us, mostly against us in reality. And, to a fair degree, the Native Title Act is another one.
I might ask Matthew, bring some of your experience from the Northern Territory and what you've seen happening in Victoria, but is the Native Title Act a confused mess, end of the Australian nation as we've known it, as per Hugh Morgan, or a new beginning?
To me, the Native Title Act is really a question of what was hoped for, what was anticipated. And I think the whole Mabo decision has got to be set in the context of a history of Australian reconciliation with its Indigenous Aboriginal and Torres Strait Islander population that was essentially a wasteland, with very few features on that wasteland, perhaps the 1967 referendum. And so when the Mabo decision was handed down in 1992, because there was so little else on the reconciliation landscape, huge expectations arose out of the Mabo decisions. Huge expectations on one side and sort of fear and loathing on the other side. But I've worked all of my practicing life as a lawyer with the Native Title Act, and Mabo, even though it was very symbolic, cut of everything else, shorn of the political hyperbole, it was a property law decision. It was a property law decision, and when I was teaching property law, it was very interesting, an anomaly to the doctrine of tenure. And that's, from a legal point of view, all it really meant. Now, when you have a decision like that is significant from a legal point of view, but just a decision about tenure and the doctrine of tenure and its application in Australia and how that worked with Indigenous peoples, the expectations arising from that were, I think, overblown. Now, as Adam said, I spent quite a lot of my life working in the Northern Territory where establishing native title is a lot easier. But even so, establishing native title just means there's a recognition that land in the Northern Territory, and I think to a certain extent it's true in Victoria, but I might come back to that, land in the Northern Territory was subject to the ownership of the Aboriginal people in the Northern Territory. Now that's had an impact. Of course, in the Northern Territory there are other factors at work as well, like special legislation. But in reality, and I think this is true for most of Northern Australia, they were covered by pastoral leases. Under native title law, a pastoral lease will partially extinguish native title. And so Aboriginal Australians in Northern Australia will generally get what's called non-exclusive native title rights. Their rights to hunt, to forage, to camp, to light fires, to undertake spiritual activities, they're important for Indigenous people in the north just as they are in Victoria, but it's not life-changing. It's not something that's going to alter the framework of Indigenous, non-Indigenous relations in Australia, and nor could it ever be. Mabo wasn't some government program, it was a High Court decision about property law. I think when we bring that down to Victoria, you also see the limitations. To establish native title today requires really two things: an ongoing what's called connection and an absence of extinguishment. Now in Victoria, I think about 70% of land in Victoria is held under freehold. That necessarily means there cannot be, under native title law, any native title in that 70%. In 30%, which is Crown lands, public lands, you can have that non-exclusive rights that I was talking about. So that's the best you're going to get. But to get that, you've also got to deal with the issue of connection. And connection means, as we found out in the Yorta decision, that essentially you've got to maintain what the High Court calls a continuing normative society. Now, there's a lot of debate about that, but it can be difficult, but not impossible, for Victorian Aboriginal people to establish. But just say they do that, at the end of the day, you arrive at these non-exclusive rights over that 30% of Victoria, which is essentially the national parks, the beds and banks of rivers and so forth. Is that going to be life-changing? No, I think it has been significant for Australian Aboriginal and Torres Strait Islanders to be recognised as the first owners, but recognition is, I wouldn't say token, but it's not everything. It's not that foundation for economic development. And that's where I think the Victorian legislation, the Traditional Owner Settlement Act, the Settlement Act, as we call it, not TOSSA, the Settlement Act is important because under both the former government and the Baillieu government, there is a motivation to use that act and have native title as a foundation, but just a beginning, not an end, as a foundation to try and achieve better outcomes. And I think that's where native title's heading now. But as I say, has it achieved as much as Margaret or Gary would have wanted? I'm sure it hasn't. Could it have ever done? I don't think it could have. It was a High Court property law decision. And at the end of the day, it remains a High Court property law decision.
Yeah, Gary, what are your comments on that? I mean, you've been around the native title for a long time. Is it a foundation? Did it provide a foundation that should be moved on from, or does it really dash your hopes and aspirations for it?
20 years is the anniversary. Well, let's try 120,000 years. Let's try 80,000 years, 40,000 years, you know. The more they dig, the older we get. And Mabo, whilst it's gone on for 2 decades, you know, you've got to reflect back on the 38 First Nations with their unique traditions and customs and observances and beliefs and cultural heritage that were here before the Dutch, before the English and everybody else, who had country, had boundaries, had authority, lived in a good environment, clear water and all that sort of stuff, and could fish and hunt and gather without having to get a licence, whether it's a native title licence or a newsagent's licence down the road for $20. I think that's a starting point, and you know, what really underpins it is 27 million acres of Victoria was part of those unique nations business. 27 million acres, that's Victoria. That's not counting southern New South Wales, where in the 38 First Nations there's probably about, 16 that are cross-border groups. So we head into New South Wales, Wamba, Barat, Judaroa to a certain extent, etc., etc. 27 million acres has been reduced to around about 0.001%, which is about, if we really add it up, Lake Tyre's big tract of land, 3,000 acres, Framlingham about 2,000 acres, it's about 25,000 acres. It's not even a black dot on the map. Now, if we're ever going to get anywhere, we need to have economic development. And economic development at the moment is owned and controlled by non-traditional owners who own the best parts of Victoria, where the law makes sure that native title is extinguished because of freehold, and there's a little bit of Crown land left, and therefore we've got to fight over it. I remember when I was a kid at school, I got called Abo and Boong and all that. And when I grew up and got married and had kids and got involved in native title, I actually had to prove I was an Abo. I had to prove it. And, we have a go at it, connection reports and research. All this wonderful research has been done. I went to my first meeting with my mother, passed away in 2010. In 1997, January, we went down to Wimmera, to the desert country, Wadjabolik country, Jardbajala country, Jupagog country. We went to that meeting, and that was hot and, stressful type thing to go to, but we went to it. And since then, we've had native titles about a right to hunt, fish and gather. I haven't caught a fish under it. I haven't hunted possums for my possum skin cloaks. I've had to buy them from New Zealand, $50 each for a skin, 30 skins in an adult cloak, half that for a child's cloak. Although those possums originally came from Australia, because there was a land bridge. But now they're big possum skins, they got tats like Maori people got and all that sort of stuff. They're different possum. But we have to buy those possums from New Zealand to make our cloaks because it's illegal for us to hunt. And even if we got a native title right, there would probably be some sort of regulated process that we would have to do. For example, we'd have to get a native title licence. Well, what happens if the native title body refuses your membership? Even though you're a native title holder, it's just an example of how the administration of Mabo and the Native Title Act and the state acts around this country, but particularly in Victoria, can let you down. Native title is an industry. Sorry, Adam, but lawyers are getting rich off it. Researchers are getting rich off it. There's not many traditional owners employed in it, particularly in Victoria. We're the clients. Me and Marg were Adam's clients. And I really think that if native title was a business, it would be liquidated because it would be insolvent. And the reason why I say that is because, by my estimates, since '97, there's something like $50 to $60 million been spent in Victoria on native title processes, meetings and meetings and meetings, research and research and research, and lawyers and lawyers and lawyers. Yet we've only produced, for that $60 million, agreements, which, if I throw that on there, and you see that as a phone book, the Melbourne White Pages, that's the extent of the documentation that's done in order to get a deal, to get an agreement, to get an ILUA, to get registered in the tribunal, to get a determination in the federal court. Why does it take 12 years to get that document and to get the benefits that flow from it? For example, the native title right to hunt, fish and gather, if you're successful in that. The right to get funding to run an office and a business maybe, and other things. Why does it take that long? Why do we have to see our elders and our young people die before they get a right? And in fact, in most cases, the only right they get is the grave they're buried in. We have seen lots of people in that last 15 years not see those rights.
Oh,
It's not Mabo. It's not Mabo. Not blaming Mabo. I think he opened the door. He kicked the door down for us. But it is the maladministration of native title law, land rights law across Australia in terms of New South Wales, Northern Territory, that is not picking up the justice, the reconciliation issues properly.
Matthew, all right. You've heard what Gary and Margaret have said. Margaret talked about preparing a claim, but it not really being worth the while to pursue it. Gary talking about things taking too long. Have you got any hopes for the scene changing in Victoria under use of the Mabo decision and native title?
Yeah, I think, Adam, in your introduction you were suggesting a time frame for resolution of native title claims of another 10 or 20 years. I certainly don't think that's the case. I would hope that we'd be looking at resolving the vast majority of native title claims in Victoria in the next 5 to 7 years or so. But I come back to, and this is where I've got to agree with Gary and Margaret to a large extent. This is the thrust of what I was saying before. We can work to resolve native title claims, and we can do that, and as I say, under the Traditional Owner Settlement Act that was passed recently, I would expect that process to be quicker and more favourable for traditional owners. Certainly that can be achieved, but again, the expectations of what's going to be achieved from native title, I think are continuously overinflated, and that's because, and I come back to what I was saying before, if you look at Australia's history of reconciliation, it's a wasteland. There's very little in that space, apart from Mabo, apart from the 1967 referendum. I think today governments, particularly Commonwealth governments, are starting to look more seriously. Where I was in the Territory, I think the Commonwealth is starting to appreciate, for example, the expenditure necessary to improve in Aboriginal housing in the Northern Territory. But the extent of the problem is so overwhelming that even the Commonwealth Government resiles from it. Here in Victoria, I think there's been a tendency to ignore the issue because it's much more ignorable than it is in the Northern Territory. And so for people to pin hopes on native title is, as I say, an over-expectation. It can do some things, but it can't do everything.
Margaret, as following from that, what other avenues do you think you can deal with? You've got your corporation that's up and running well. What other avenues do you think that you could utilise if it's not native title, if it's not Mabo? Or do you pin all your hopes on the Native Title Act?
I think it's coming down to just being totally self-sufficient. We have people with skills, we have people with qualifications, we have people with knowledge, we have people with the energy and the intelligence to pursue some autonomy and self-sustainability, self-determination, self-direction. And I think that's sort of part of the way that we'll have to go. We can utilise what's already there in law, but they're only tools. It's up to us how we use them and whether we use them at all, because I don't remember anybody asking for a Native Title Act. The Native Title Act came out of a Royal Commission into Aboriginal deaths in custody because there was so much concern, finally, about all the people that were dying while they were in custody and the way they died and the reasons they ended up in jail or lockups to die or die on the way to the whole thing was very serious and very sad for a lot of people all over Australia. So Native Title Act was was pinned to some of the recommendations that came out of that. So yes, we can't blame Mabo, the Mabo case, just for that, but they had rights to, and that's what he wanted. He wanted the right to be able to plant a crop on his own little area of land that he'd known was his from before he was born. He knew it was his family's, and that's what he wanted. He just wanted the right to be able to say, well, this is mine. If you want to do something here, I might share with you, but you need to ask first. Fair enough. You don't walk up someone's driveway, open their front door and just walk on in. There are protocols. So you knock first, and that's basically asking for permission to enter. That didn't happen across Australia in a lot of places. In a lot of places, there are no nations left, no descendant clans, no descendant people, no descendant family groups. That's shameful. We don't need to go too far back into the past, but sitting here listening, I had a thought. I'm a bit of a conspiracy theorist. I'm starting to think native title was even invented to, at some point at the end of the day, wipe out our rights by a negative judgment, or even with a positive judgment, you sign away your rights forever and a day until somebody comes along and changes the law in the future, and I don't think that's going to be us, or my generation anyway. I'm starting to think, well, perhaps it's just a way of finding out how many of us there are and who we're related to and what land we say is ours, and a way of controlling us again. So, anyway, I won't go on too much about that.
I think it's a pretty pessimistic view of what native title can achieve, or what Matthew was saying, that to be realistic about it, native title in Victoria can only produce so much, and how do we grow upon that? I might just throw it open to the audience if there's anybody that has a question for any of the panellists.
I think it's time we introduce a jury in the courts, not this continued star chambers which were abolished in the 16th century, and on the jury to have some elders on the jury to make the right decisions so that their rights, they get their rights to their land and continue to have a happy life.
All right, thanks very much for that. I should make it clear that although there are a number of native title claims in Victoria, none are currently progressing to trial. So we're not into calling the first witness and running the cases in the federal court. All the native title claims are in mediation, court-assisted mediation, to try to see if we can come out with an outcome. Now, the judge who's in charge of all of the cases in Victoria gets quite cranky when we turn up and say, if we haven't got some forward movement as far as negotiating outcomes. And so that's what this new legislation, the Traditional Owner Settlement Act, has been brought in to really try to force the parties to tick the boxes and reach an agreement. So we're not at a trial yet, but if we don't reach agreements, that's where we're going to go. Another question over there.
I just have a question about the kind of social cost, I suppose, of native title, because you've been talking about how tough it is to prove who you're related to and a connection to a particular place in that very specific way. But so it must be so much tougher for Indigenous people who cannot do that. And I imagine that in Victoria that's particularly a problem. So I'm just wondering whether you would see that as something which is perhaps collateral damage of native title, and if that's something that has been recognised as a problem to be addressed.
Yeah, well, obviously, if you're part of stolen generations, you might be 5% of a traditional owner group that's part of that stolen generations. Therefore, they're going to have it difficult to prove who they are. But probably 95% of us can say, well, here's me, here's my mother, here's my grandparents, here's my great-grandparents. I can roll my tree out to the back of this hall in most cases, right? I can go back to 1790 or 1800s in terms of who I am and where I'm connected. And I go across 8 or 9 clans, and I have no problem about doing that because of what's happened to us with dispossession and the impact of the invasion and colonisation. We have to look after our clans. Our clans are the most crucial part to this native title puzzle. A clan is mum, dad, uncles, aunties, kids, grandkids, grandparents, etc., etc. A clan has got particular country, it's got its own traditions and customs. It is the clan that is the land-owning group in this state. Where we've been screwed over is by the fact that the state of Victoria and other parties recognise language groups only and do not want to deal with family groups and clans. That's the myth of it. That is what's killing Victoria. Victoria should be about building the quality of life and the living standards of family groups. We do that in the welfare, the Aboriginal welfare industry. We really focus on families. But in native title, we don't. They're trying to get us off the agenda as fast as possible by saying, well, look, let's deal with all ears under this melting pot arrangement, I call it. We get a corporation done and it's a melting pot corporation. All the clans are thrown in there. The strong clans survive. The rest get disappeared. And that's the danger we're facing at the moment. And the second thing is, when the Native Title Act came in 93, just after that, the Indigenous Land Corporation was set up, and also Indigenous Business Australia. I think the native title industry is so incompetent about coordinating the other aspects of getting land justice. ILC, for example, has bought back 6 million hectares nationally, 6 million hectares of land on the commercial market. A lot of it cultural land, a lot of it commercial land. In Victoria, they bought back a paltry 4,000 hectares. 4,000 hectares out of 6 million hectares. That's not equity. Yet the ILC was set up for the most impacted, the most dispossessed, the most dispersed. There's a contradiction there. IBA, which is Indigenous Business Australia, is another multi-million-dollar statutory body that is set up by the Commonwealth to assist Aboriginal people with economic development. Well, they've done heaps of things. They bought Kings Canyon up near Catherine. They bought Lake Mungo Resort, Lake Mungo near Barrow, etc., etc. You go on a website, you'll see what they do. They sold their share in a mine in Newcastle a couple of years ago, and they made $123 million profit. Then they came to Victoria and wanted to buy it. They wanted to do something, but they couldn't find nobody to do anything with. And they've got a couple of projects down in the southwest of Victoria. So what I'm saying is, if you combine the strategies in land acquisition, economic development, cultural heritage and native title, you'll get to where we want to go. You'll start getting land back. You'll start getting economic development activities. You'll start getting the recognition and the resources that go with that. But it's not happening. It is all over the place. It's like a jigsaw puzzle that someone's pulled out of a box, thrown it on the floor and said, all right, you blackfellas, go for it.
Well, that's the sort of thing I wanted to get to is what other strategies beside putting all our eggs in the native title basket. Matthew, have you got a comment on that?
Look, again, I'd agree with a lot of Gary's saying, but I think this is part of the significance of the approach that's been adopted in Victoria now under the Settlement Act, is you are seeing much more work with the Indigenous Land Corporation and the IBA. But mention Indigenous Business Australia, mentioning those two bodies, though, reminds me of something else I wanted to highlight. Adam was talking about the Redfern speech, Keating's famous speech in Redfern Park back in the 90s when it was all being debated. The significance of that Redfern speech, as I recall it, is what Keating was focusing on was recognising that native title won't be able to assist many of Australia's Aboriginal and Torres Strait Islander people. What the Redfern speech was about was Australian government, Commonwealth government's commitment to doing things beyond native title. Now, really, the only manifestations of that came out immediately were the IBA and the Indigenous Land Corporation. And I think, to a certain extent, this is where I'm saying it takes more than native title. IBA and ILC do some good work. There can be some legitimate criticisms of some of their work, but some of what they're doing and where they're heading is right. But it's such a small drop. If that was meant to be the compensation for, as Margaret's saying, losing the rights, and to a certain extent a determination of the federal court is a catalogue of the rights that have been lost, if that's meant to be the other side of the equation, the IBA and the ILC, then that just doesn't stack up. Because IBA and ILC, despite the good work they do, aren't compensation for everything that was lost by Australia's Indigenous populations. And that's where all governments, and as I say, the Victorian government's doing some good work, but certainly it could do more. Same with the Commonwealth government. There's a lot more need be done beyond, well, I suppose, to carry on Eddie Mabo's work.
All right, thanks. And people are aware of the Indigenous Lands Corporation and from what has just been said, but the idea was, when the Native Title Act came about, is a recognition that people might not be able to prove native title, and they put a pot of money aside, and that pot of money was meant to buy land and acquire land for those people who weren't able to establish native title. But the comments are that it's not nearly going far enough. Is there any other questions or?
Thanks. Keith Gove, co-chair of Reconciliation Victoria. We've been doing some work on treaty or treaties, and I'd be interested in people's views about that as an approach. In particular, we've been looking at local level agreements between local governments and the local traditional owners. It seems to us that there's a fair bit of opportunity through that local negotiated agreement approach. And I'd be interested in the panel's views about that as an alternative, perhaps not a fully legalised approach to solutions.
I'd like to respond to that one. Treaty is an agreement, keep it simple. Obviously, native title has distracted us from the main game, which is treaty and sovereignty and reparations, ongoing compensation. But also treaties about traditional owner groups, First Nations. If we're claiming to be sovereign, we need to do treaties amongst ourselves too. And it just so happens that in the northeast, the Yadamatang group, First Nations, and the Judaro and the Wairau did do a treaty. And we drafted it up, 30 pages, and it was a cooperative management agreement between the three groups and cultural heritage management and all other sort of things we do up in the Alps. If we can't treaty amongst ourselves, how can we ask whitefellas to do a treaty? So I think the first step from our point of view is to get those treaties going amongst ourselves. And we're keen to do treaties. But also there's that question of sovereignty that goes with treaty, it goes with ongoing compensation. And where does land rights legislation fit into in Victoria? We haven't got land rights legislation here. We have got the lowest form of land title in property law, right? Native title is on the bottom. But now we've got another one, and it's called Aboriginal title under the Traditional Owner Settlement Act, Victoria. Right, we talked about TOSA. Well, TOSA allows us to negotiate with the state of Victoria to convert Crown land to Aboriginal title. Now, what is Aboriginal title? Well, it's old Ted Bayou moving one bit of paper from this pocket to the next pocket. We can't mortgage it, we can't use it for security to do economic development projects, etc. But we get the honour of setting up a traditional owner management board, and it's a majority of traditional owners, and we get to manage that Aboriginal title. Now that could be a national park, or it could be some clapped out land out the other side of Sea Lake. But that's where we're at with the state of Victoria, and that was inherited from the Labor government, and the Liberals thought about knocking it over, but when they looked at it, they were probably laughing. They thought this is a good deal for white fellas and a bad one for black fellas. So the jury, from a traditional owner's perspective, is still out on that Traditional Owner Settlement Act, the TOSA thing.
Right, and it'll be a bit of watch this space, I suppose, because we're involved, all of us here, in the first comprehensive agreement under this new Traditional Owner Settlement Act. We hope to have that sorted out towards the end of this year, early next year. But in answer to your question also, I think my experience, especially in New South Wales and southern Queensland, to have a suite of agreements, especially with local government, becomes really important. The local government and local Aboriginal communities, there's a lot in common and a lot of work that needs to be done there. It's all very well to have these statewide agreements, but down on the local level, I think they're extremely important, and they actually produce most of the real things that happen on the ground. So I'd support that whole suite of agreements. Call it a treaty, call it what you like. So from my experience is that they often work really well.
They would be called, well, most people would think of them though as reconciliation action plans, RAPs. We're attending the Parliamentary Review Committee in the morning to talk about RAPs, not reconciliation action plans, but registered Aboriginal parties. Odd how things just coincidentally seem the same, but they're not, they're worlds apart. So reconciliation action plans are terrific, but it needs to be a bit more than agreeing to fly the flag out the front of the town hall. It needs to be more than state government agreeing to name some rooms in a new building with an Aboriginal language word. There's a whole lot more. Somebody many years ago, when Murrumbidgee Nation's Aboriginal Corporation was still operating as the native title representative body here in the state, so that's pre-Native Title Services Victoria, said, well, why don't we look at getting a percentage, and it would only be a small percentage, of the land tax that could go to all the groups around the state to help them get on their feet and start doing things for themselves that they want to do. whether it's buy land or buy some houses so that people finally have, you know, a roof over their head that they can call their own and not be paying rent. I've been paying rent for more than 20 years. Imagine, I probably could have bought a house by now. But that's the state that everybody's in, and we need to start thinking about, well, what is there that we want to do in the future? And that is, as I said, self-sustainability. We want to set up our own enterprises, our own business development stuff. We want to look after ourselves. We don't want to be told how to do it. We don't want to wait in line for any so-called benefits to allow us to do that, when all we're going to get is, as Gary said, participation on a joint management board of a national park. Well, wacko. Wurundjeri was doing that with the Police Paddocks Committee of Management back in the early 80s. Been there, done that. The Traditional Owner Settlement Act is not going to do a lot for groups in the state, nor is the Native Title Act. Forget that, it's gone. And I remember going to meetings in Canberra where there was going to be a sunset clause thought of, and that was the Howard 10-point plan. And I don't remember that actually getting knocked off, so there will be, like federal government isn't going to think of someday cutting off the money from FACSIA to fund Native Title Services Victoria to provide resources for groups in Victoria to meet, because let's face it, we're all landless and dispossessed and yellow fellas down here, see? So all the dollars are going up north, but, oh, that's right, there's an intervention. So they're going to try and control us one way or another, and I think we're just going to have to get pretty smart about how it is we duck and weave and start being chameleons, I think.
We might have time just for one question.
Just to pick up on one point, Margaret, and I ask this of the audience, this is my question to you. Where do you see us in Melbourne? Where do you see us in the CBD? Where do you physically see us and spiritually see us? And one of the projects that came around when Kevin Rudd first got in as Prime Minister a few years back, how things change, eh? He called a summit, and one of the recommendations that came out of the summit was a national Indigenous Cultural and Knowledge Centre concept should be developed. And they allocated funds for feasibility studies and all this sort of stuff. At the same time, Victoria, traditional owners, Joint Traditional Land Justice Group, the City of Melbourne, some people from the State of Victoria and also the University of Melbourne School of Architecture, set up a working group to look at potentially building a $500 million building, 2 towers, one accommodation and tourist stuff and university sector and all that sort of stuff. The other tower, business in terms of cultural heritage, museums, restaurants and everything else that brings people to the city. And the purpose of that concept was for traditional owners across the state to own it and to reap the benefits from it. It would also be a gateway to every other traditional owner group who was building a smaller scale building up in the Alps, out in the Mallee, on the Murray River, on the coast. That's the concept that will bring economic and cultural development to the City of Melbourne. That will create the physical presence. So how do we finance it? Well, you know, we got the ILC, we got IBA, we got native title settlements and all that sort of stuff. Maybe we need to go to China and get them to finance it. Or to America and talk to our Indian brothers and sisters over there. Or to New Zealand and do a partnership. But that's the level we got to start getting our business thinking around. That's the level. Because you're not going to get too much out of native title rights and interests. A right to hunt, fish and gather as an individual does not make you self-sustainable. It allows you to go to fish, go and catch a fish for lunch. But you can't put a trawler in to make a living out of it. So we got to get free-thinking, lateral, creative about the economics. And we've got to use native title as a tool to get there.
All right, that's a good comment.
There you go.
And that's what I was hoping to get, is a bit of forward thinking, because I'm going to ask the same panellists back here in 5 years and the same panellists back in 10 years, and we'll see if we have got to achieve those sort of high aspirations. So look, I thank the panellists for coming along, and I thank everybody else for coming along.